The NPA has confirmed that it was served with a petition by legal representatives of Dr. Nandipha Magudumani seeking leave to appeal the Supreme Court of Appeal's judgment that was delivered last month. NPA spokesperson Mthunzi Mhaga says they will defend the matter when it's heard at the Constitutional Court. Now, remember last month, Magudumana suffered a legal blow when the SCA dismissed her application to nullify her arrest in Tanzania, and she approached the SCA to reverse the decision of the Free State High Court, which also dismissed her application to nullify her arrest on the basis that she had consented to be brought back to the country. 4 justices dismissed the case with a dissenting judgment in her favour. Let's speak now to Magudumana's lawyer, Machini Motoung, who's joining us this evening. A very good evening to you, and thank you so much for your time. So, are you relying mostly on the dissenting argument that was in her favour as you take this matter to the Constitutional Court?
Thank you, yes, for the opportunity. I think where we are now, we still firmly stand by the grounds of appeal that we presented in the SCA. But obviously, over and above that, the issues which emanate from the dissenting judgments are quite compelling in our view, and worthy of really being pursued further in the Constitutional Court. So there are conglomeration of factors that we are raising in our papers, which we would want to fully and expansively ventilate in the Constitutional Court.
But what is that one matter that you bring this up on?
Obviously, the issue that is really central to our arguments, has to do with the so-called consent that she allegedly gave to an illegality. That's one part of it. But the second part, which features prominently in the judgment of the majority, has to do with the issue around disguised extradition and the stage at which this point was raised. We're coming up with legal arguments to the extent that there's been consistency in our papers, in our arguments, that what happened in Tanzania in any manner, shape or form constituted what we call disguised extradition.
And of course, when you look at part of that, the dissenting judgment in that very part that you're speaking about of the dissenting extradition, it's by Mahuka J.A., right? He says that I do not agree with these conclusions. As to the first, I endeavor to demonstrate that the appellant did not make a new case in the replying affidavit, but that the unlawful disguised extradition argument arises fairly from the founding affidavit. In addition, I make the point that the unlawful disguised extradition is a point of law which can be raised at any stage, even during an appeal, subject to certain provisos. So how confident are you that you'll be able to, as her representatives, to make a case, a very strong one, to the Constitutional Court around this particular issue of this disguised extradition?
Look, obviously we had to peruse the judgment and critically look into the findings of the majority judgment, also dealt with the findings of the minority judgment. We applied our minds sufficiently to those points, and we came to a conclusion that taking the matter further is actually something that would be warranted, as we are of a firm view that we have a meritorious matter here, hence our move to approach the Constitutional Court in terms of Rule 19 of the Constitutional Court rules, to have application for leave to appeal granted, so that we are afforded that platform to ventilate our matter sufficiently before that court.
How confident are you that things will go your way, given the fact that the NPA says it is going to be defending this particular matter?
We expect that. We expect the matter to still remain opposed, even at its own genesis. It was opposed right through the Supreme Court of Appeal. We didn't expect them to just look at our application for leave to appeal and do nothing about it. But we remain confident in our matter. We are of the view, and a firm view for that matter, that there are prospects of success, in this application for leave to appeal, and that another court, and in this instance the Constitutional Court, may as well arrive at a different conclusion. So we remain confident on the merits of our case.
Just before I let you go, how is your client doing with all of these developments around this matter?
She remains resolute and confident in the justice system. Hence, we are following the due processes. Of course, as I always say, she might be dismayed, but definitely she's not despondent. She's prepared and ready to really see that justice ultimately gets to be done in a case, as she firmly believes that there was unlawfulness in the manner in which she was handed over to South African authorities, and hence she's pursuing this route.
All right, Mr. Motoung, appreciate your time this evening. That's Machini Motoung there, the lawyer to Nandipha Magudumana, saying that they're going into this confident that the Constitutional Court may come to a different conclusion than that of the Supreme Court of Appeal. Remember, it dismissed her application to nullify her arrest in Tanzania.